Hello, credit union executives. Welcome to See You on the Show, where we give you up-to-date information on how you can reduce risk, keep key talent, and take a strategic approach to your personal financial wellness. Hosted by me, Doug English, a certified financial planner and former credit union insider with ACT Advisors. My guest on today's podcast is Jeff Cardone. Jeff is a partner at Luse Gorman. Jeff specializes in helping credit unions and other financial institutions with mergers and acquisitions, executive comp, employee benefits, and tax planning. In this episode, Jeff shares how the merger and acquisition process begins, what to look for when planning for your merger on the comp side, and the importance of understanding your employment contract. So Jeff, in our talk today, we're going to discuss how credit union mergers and acquisitions activity usually begins. So tell me, how do you see them start?
Well, the way a lot of these deals consummate, particularly as a credit, I have to say, there's what I'd call the formal solicitation process, where a credit union says, look, we're at a point in our business where we're ready to partner up with another institution. We're going to hire sort of an investment advisor, or we call it investment bankers, to go out and solicit and call other bidders or potential acquirers. So that's kind of like the formal process. Like the board has determined at this point, yes, we're ready to move and we want to kind of partner up with another. I'd say that's probably less common in the credit union. More common the way deals are consummated is more what I call the informal way.
Mm-hmm. That's what I expected.
Yeah, where CEOs and board members are going to conferences, they have relationships with other credit unions, and you just have conversations, lunch meetings, and you get to a point where, hey, it may make sense. Like, let's partner up. Let's have discussions about combining economies of scale. And I'll tell you that is probably more common in terms of your question of how does the process start? It usually starts with a conversation on an informal basis. So you can go the formal route or the informal route, but in the credit union space, I'd say it's more the informal route leads to deals. All
right, so discussions start between the board and the CEO, or the two CEOs, and at that point, what's the next step to determine if this is a waste of time or maybe this really has legs? What do you see happening next?
The next logical step, because a lot of times the numbers make sense, the metrics, you gotta really drill down on the social issues, particularly if it's what I call merger of equals. Generally, credit unions at the same asset size, board seats, composition, senior management team, name of the credit union. Are we going to keep employees, branches, that kind of thing? I mean, I think you really have to address those, because until you really do that, getting to the more formal phase of a deal would just be sort of a waste of time, because because the numbers make sense, but you might say, well, listen, we have two individuals, you can't have two CEOs, you can't have two CFOs, you can't have two chairpersons. So you really have to work that out. And you're just really going to take two institutions, particularly when it's a merger of equals, that really want to work together. Now, if it's the other way, where you're a much smaller institution, or maybe it's not quite a supervisory merger, but you're at a point, we really got to partner up with a much larger institution, then look, you're not going to get equal representation on the board. There's not going to be even split amongst the management team. So a lot of it depends. But the merger of equal types, you really got to drill down on the social issues.
Interesting. So the social issues you're defining as who gets the board seats, who stays as the leader, and who's the CEO, who's the president, and that sort of a structure. When credit unions begin these talks and just exploring them, what sinks the ship? Is that what stops it usually? Is both want to be in charge?
Yeah, I would say that's probably, I'd say, number one. Number two then is the field of membership. Can you make that work from an onboarding perspective? Does that work? Do we have to go to the regulators or the NCUA and kind of expand our field of membership? We've had situations where that caused deals to not come to fruition and whatnot. So I would say those are the big two. The other key piece too is that kind of once you work through the social issues and you're kind of ready to, I think then And the third piece would just be, are there any safety and soundness issues that, the regulators would prevent the merger from happening? So I think once you're at a point where you have a meeting of minds on the social issues, the next phase with them would have like a more formal letter of intent or a term sheet to kind of lay out what those are and whatnot. Then you say, okay, let's go talk to the regulators just to give them, not that they're going to give you a definitive answer, like, yes, we're going to approve this, but sort of, is there anything out there? Is there any reason why this can't happen? Looking at our field of membership, looking at our charter and whatnot. And that's kind of the next step, because you want to make sure that's not going to be an issue as well, in addition to the social issues and whatnot.
Well, let's go a little deeper on what you said about safety and soundness issues.
If you're a 3-rated institution and you have, for example, BSA issues, I don't know, the NCUA is probably not going to allow you to acquire another institution, because they want you to kind of get your ducks in a row first before you're sort of on board and grow. So that's an example where there could be safety and soundness issues. Usually on the sell side, that's not so much an issue, because frankly, if there's an issue with the credit union, the NCUA is going to want you to merge with somebody else, a more healthy institution. So it's really on the acquirer side, or the continuing credit union. Is there anything out there? BSA is certainly at the top of the list in terms of, if you're deficient there, that could really cause a deal not to happen.
So let's pretend that there's two credit unions and they've kind of gotten into they've got maybe some overlapping footprint in the community that they're in. They like each other. They're thinking maybe there's something to it here. You mentioned term sheet, LOI. That's clearly an area where they've reached out to their attorney and they've begun a more formal process. When the credit unions have gotten to that stage, I know you told me a story in preparation for this call about a rogue director and kind of things to watch out for. Can you share that with our listeners?
Yeah. Well, I think that issue, yes. So I think once you're at that point, things to what you want to make sure you want the board acting as one. Certainly, if there's some issues, and not that the boards aren't going to debate, but really, if you're going to undertake a sale process, or you're going to merge with another credit union, you want the board to kind of be in lockstep with one another. Yeah, just to reiterate the story that I had told you, was we were involved in a situation where, because you have to get a member vote to approve the merger if you're going to merge with another institution, and one of the directors was sort of going out and calling members and sort of soliciting, saying, don't vote for this. And that ended up kind of causing the deal not to come to fruition and whatnot. So that's sort of a one-off cautionary note, but obviously acting in concert is important from a board perspective. The other thing that comes up too, and we talked about this before, that's real sensitive on if you're merging, is the compensation arrangements. Because for the CEO and for the next 4 covered persons, and also any board members, anything that's being paid in connection with the transaction has to be disclosed both to the regulators and to members.
All right. Yeah, I really want to go deeper on this, Jeff. Thanks for bringing that up, because in prior interviews, talked to executive benefit specialists, and when they are involved in a merger, both institutions, but certainly the one being acquired, the executives tend to get immediately vested, right? It's a change of control. So if they had a benefit that was going to vest over 15 years, but 5 years in there's a merger, there's a huge event, right, that is going to occur at that change of control. So talk us through what happens. How is that disclosed? How does that work?
Yeah, so so the NCUA, they're not prohibiting merger-related pay. When I say merger-related payments, like an easy example of that would be CEO has an employment agreement, and on a change of control, he or she would get 2 times or 3 times, whatever the multiple is of base salary. I'm using that as an example. Or you have like a 457F plan, which has a provision that you have to work to age 65 to get your benefit. Let's say CEO is 60, and then as a result of a change of control, that F benefit accelerates. So it's really what they call a but-for test. Like, is this being but for the merger? Would this dollar amount be paid? And if it's being paid as a result of the merger, not only you have to disclose it, the existence of the plan or the arrangement, you also have to quantify it. And that could kind of lead to some issues. So again, the answer is not saying you can't do it, but they want full disclosure. And then this could create for CEOs and management teams a little bit of political issues because now it's going to be in the public domain, both to the employees and members, what they're getting paid. And there's a lot of sensitivity to that as well. So that I would say is also part of the process as you're planning for your merger on the comp side is to kind of look at what your existing plans are and how is that going to quantifying that? How is that going to be disclosed? Are there any issues with doing that?
All right. I want to go deeper still because this seems like a real area where strategy, where being ahead of this activity could prevent a lot of difficult conversations. So you've been through many transactions that had these events, these disclosure requirements and delicate dancing, I'm sure, around them. What could those executives have done years prior to have either sort of managed those perceptions or to change the need, to make it less impactful, the amount of disclosure that's required? What sort of strategies could they be thinking about in advance to make that less difficult?
Yeah, I mean, the one thing the rule does contemplate, they sort of have a safe harbor 2-year window. So like, for example, if you enter into an arrangement, like right before you're having your merger discussions, like that's the NCUA is clearly going to view that as merger related. But like if you had an F plan, well, at least 2 years prior to the merger, or you enter into an employment agreement, and if that just sort of carries over, because a lot of times what happens in credit union mergers is the acquirer, the continuing credit union wants to keep the senior management team for a period of time. So they might say, look, we're not going to pay you severance, but if you stay for 1 year, 2 years, 3 years, that's great. And then you sort of get paid, the management team sort of gets paid that way, sort of indirectly, while it's not severance. And that kind of softens the disclosure. So the selling credit union had these arrangements in place prior to the merger, at least 2 years in advance. NCUA's view on that as well, that's kind of just rolling forward. That's not really an agreement that was entered into because of the merger, and that kind of softens the disclosure obligations for that.
So would that also apply if you had a 457F 10 years ago?
Yes. Yeah. We have a situation where a merger I'm working on right now, CFO has a F plan. And the nice thing was it was in place for the last 10 years. There's really no true accelerated provision. There is some termination protection. But again, because this was a legacy plan that was in place well past the 2-year safe harbor period, the NCUA's view on that is that's not disclosable, that's not merger related, and they were comfortable with that. So there's sort of things to do. There's sort of ways to get the covered persons, the CEO, their money, but in a way that's going to kind of soften the disclosure from a political perspective. And again, planning's key. You clearly got to do this well in advance of undertaking the merger process. Now you go the other way. Some covered persons might say, we don't care about this disclosure. We want the protections. We want to get paid. And we sort of built the institution and sort of is what it is, for lack of a better legal phrase. But then you just disclose it. And again, to reiterate, the NCUA is not saying you can't pay severance. They just want the members aware of what that is because of that conflict of interest. Because the covered persons are sort of the ones making the decision, the board members, the CEO, about the sale. And they don't, and obviously getting paid severance is a conflict of interest to members. And so again, as long as it's adequately disclosed, the NCUA is fine with it.
In the example you just cited, did that executive experience immediate vesting because of change of control or not?
In the one we're working on, no, they did not. So that made it not, but if it did, we would have to disclose it.
So that's a really interesting point. So I'm used to seeing change of control as part of the contract. I don't know how frequently you see that, but I know I've seen it in a lot of the credit union executives we work with. If there's a change in control, they get immediate vesting. Would you say, is that the majority of the structures that you see?
I would say yes. And when I talk to boards in the sale process, particularly about compensation, there's a little bit of this misconception, like every dollar an executive's getting paid, that's a dollar being taken away from the members. It doesn't really work that way from an acquisition, because what happens is when acquirers come in and they're assessing doing a deal, they have in their modeling expenses and whatnot. Obviously, there's no deal consideration for credit union mergers because they're cooperating owned, member owned, but you're looking at costs related to termination of your core processing, any continued D&O coverage, and compensation is kind of a part of that. So again, in some ways, from an executive, by saying, look, we're not going to pay you these change of control benefits, that's not necessarily going to flow to the members because it's kind of built in. And then the other thing boards have to keep in mind and where there's real value to having accelerated vesting provisions on change of control and these severance benefits is once you sign up a merger, the board approves it, you kind of then move to the regular, you kind of have your LOI, you negotiate what's going to be negotiated from the LOI, the boards approve it, you put together the merger plan, and you submit it to the NCUA. It's a monthly approval process. So from that time, for when you file your application and you're like, yes, we're moving forward, to when you close and then you finally execute the definitive merger agreement, you got to keep that management team in place. I mean, somebody's got to run that institution. So these benefits really incentivize these key people to stay. So there is true value to the members, and that benefits the members. In addition to value, obviously the executives are going to get paid, but that's important, because otherwise, if there was no incentive, they sign up, CEO gets a job offer elsewhere, he or she says, look, I'm out of here. Why am I staying? So that I always try to educate boards about that, because there is that misconception. It's not like, oh, that dollar, we take $500 from the CEO, that $500 is going to members. It doesn't really work that way, economically speaking.
Right. If the design is right, the retention of the management team is what's in the best interest of the members.
Absolutely. Yes. Because not in the non-banking credit union world, deals get signed up and they just close right away. But in our industry, you have a very thorough regulatory approval process. You have to have a member vote. So there is a time horizon. And then the other thing is, if you keep the person around post-closing, that they have to work to a certain date to get the severance. I mean, obviously, they can't quit beforehand. Then again, it's an incentive to not only get to closing, but also to stay on for a transition period, which is also helpful, because you can have your CEO and your other key people reaching out to key members and business relationships, and generally for keeping all the employees, just for employee morale. So there is true value in these compensation arrangements, sort of beyond what's in it for the CEO, the covered person. They're just getting this windfall golden parachute payment.
So if you were advising a credit union executive of a smaller institution about the design of their executive contract, change of control is obviously one option. Is there any kind of optionality that you could put in there that would make sense if there was a merger and there was some sort of making whole provision as a result of the merger where where the immediate vesting doesn't occur? Tell me about that.
You can do what's called a single trigger provision, where the change of control itself triggers the vesting or triggers the payment. Or conversely to that, you could do what's called a double trigger. And the way a double trigger works is you have to have first the change of control itself, but that doesn't trigger the payment. The next trigger would be the subsequent termination of employment. So if the change of control happens, let's say CEO, but you say, look, we want CEO to stay, then that's not going to necessarily trigger payment as long as you keep the CEO. But then subsequent to the merger, if the CEO is terminated, I'm using CEO, CFO, whoever the individual is, then they get paid. And you see that as well, because that kind of adds to the incentive for the CEO, like, look, or the CFO or chief lending officer, whoever the covered person is with the contract. So the double trigger is sort of another way of doing it as well.
And so is it possible that if you had that double trigger and the two institutions talk to each other and the management team that's being acquired, they get an agreement on a new compensation structure under the new entity that makes them whole, they then agree to go through the process and the immediate vesting isn't necessary because they're sort of made whole with that new comp. Is that where you're going?
Yeah, you can do that too. Yeah, because you can have the contracts, but then an acquirer can come in. This is common. They'll sit down with a key person and say, look, we want you on our platform. They may, the RF plans, our employment contracts, whatever they offer. And, sort of, we're asking you to give that up in consideration of a job and getting on our package too. It's a negotiation. And that goes back to my earlier point about social issues, particularly in these deals. If that's important to an acquirer, look, we need the CFO or this chief lending officer, this key person. You really want to try to address that on the front end during the LOI phase before you officially move forward, rather than on the back end. Because once you kind of are down that path, then it becomes more difficult to negotiate that, because now you're giving a lot of power to an executive or a key person, because he or she might say, look, I don't want to stay. But at least you're better off finding out on front end or up front than after the fact.
Excellent. One last question is about knowing your contract in situations like this. Talk to me about some examples you've seen of where folks really didn't kind of understand their employment contract, what to look for and think about if you're the entity being merged in by a larger entity.
Yeah, I would say probably the big two that comes up contractually in the know your contract is one, typically if there is severance protection, it's usually a multiple of salary and bonus. And salary is easy. You can say salary in effect on the date of termination or the change of control. But the bonus, it's sort of like, well, what's the bonus? Is it, you say, okay, bonus for the prior year. Well, is it bonus paid in the prior year? Or is it bonus earned with respect to the prior year? And those could be two different numbers. And then you may have a situation like, well, what happens if the merger closes during a partial year? Does any bonuses during that year kind of factor into that? So that is one that always comes up. Another one would be the health insurance piece. You're going to get continued coverage because pre-Obamacare, you used to be able to just continuously, acquirer comes in, let's say a CEO leaves, CF with a contract, you say, okay, you can come in our group health plan. Those days are over. So it's kind of like, well, how, if you get continued health coverage, how does that work? So a lot of times what ends up happening is you just sort of quantify it and you pay the individual out. But that could be an issue as well from a comp perspective. I mean, I would say those two come up quite frequently with contracts. The other one too is, this is really comes into play for double triggers arrangements. So you say you have a change of control, then termination of employment. But what about a situation where, let's say, the acquirer credit comes in to CEO, look, we want you, but you're going to take a lesser role. You're going to be a market president. You're not going to be CEO. And let's say CEO says, well, I don't like that. Like, I want to have the right to quit and still get paid. Would I get paid? And again, a lot of it depends on the contract, because you can put in what's called a good reason provision that says if you resign because there's a material diminution of your duties or your role or your position, it's sort of a constructive termination. So again, it goes back. I always say this and emphasize this with planning. That's why it's important to know your contract. And really, before you undertake a process you're thinking about selling, make sure your contracts are in order and everybody knows the terms, how they work, what triggers payments, what the payment amount. We talk about the bonus, how all that works. I think it's important.
Right on. Make sure you know the rules before you set out. So today we focused on if you're the entity that's being merged in. Generally, you're the smaller entity. For our next episode, we're going to connect with Jeff again to talk about if you're the acquirer and you're looking to purchase banks or credit unions, what to look for in those larger acquisitions. With that, Jeff, any final thoughts for our listeners?
My final thought is preparedness goes a long way to successful execution of a deal.
I think that was a Boy Scout saying, right?
Correct. I guess that was one word. That's my phrase. Preparedness equals successful execution.
Right on. Oh, yes, that's like a slogan. Right on, Jeff.
Slogan. There's my slogan.
Thanks, Jeff.
Appreciate it. Thanks for having me.
That's all the insider credit union knowledge we have for this episode. Are you enjoying the conversation? Be sure to subscribe and share your thoughts with other credit union leaders by leaving us a review. See you next time on See You on the Show.
The opinions voiced in this material are for general information only and are not intended to provide specific advice or recommendations for any individual security. To determine which investments may be appropriate for you, consult your financial advisor prior to investing. Economic forecasts set forth may not develop as predicted. All performance referenced is historical and is no guarantee of future results. Indexes are unmanaged and cannot be invested into directly.